Welcome to Appointed Counsel, a podcast presented by Tennessee Court Talk for those involved in indigent representation. I'm Joe Byrd, lead attorney for the Indigent Services Team of the Tennessee Administrative Office of the Courts. Episode 11, Travel Time and Expenses. In Episode 8 of our podcast, I talked about expenses in general and talked about guidelines and limitations to things like parking, lodging, and per diems. However, the issue of travel time and expenses really merits its own discussion. Now, there's two parts to travel compensation that I want to talk about today. Travel time and reimbursable expenses. Two different things. Let's look at them in turn. First of all, travel time. Now, we talked in Episode 8 about travel time that would be maybe for an overnight trial or for something that you had to go to and spend the night over. But I want to drill down into the travel time that relates to most claims that most attorneys have. Attorneys are permitted to bill for their travel time except when traveling to another county for the sole purpose of hand delivering or filing a document according to Rule 13, Section 2F. So you can't get travel time for that. In coordination with Rule 13, Section 4A, 3B, a description of the purpose of travel and the cities of origin and transportation should be entered with the claim for travel time. So you can get compensated for travel time as long as it's not for the sole purpose of hand delivering or filing a document, and you provide a description of the purpose of the travel and the cities of origin and destination. The second part of travel compensation are the compensable expenses. In Episode 8 of the podcast, I noted that Section 4A, 3C, and 3D refer to the rates of the Executive Branch and Judicial Department travel regulations. Now, the links in that section of the rule are no longer active. However, you can refer to the General Services Administration website, which you can find easily by just Googling the word CONUS, C-O-N-U-S, and it will provide the per diem rate for lodging for a particular city and the meals. Now, you have to have your receipts for meals and for your lodging submitted when you're traveling like that. But I want to focus again on the most common kinds of travel expense in most claims, and that's going to be mileage. In the September newsletter that was emailed to all attorneys who have an active registration in ACAP and they have a current email address, a short article discussed the revisions in the policy related to travel time and mileage. The new policy is, except as limited or prohibited in Rule 13, attorneys traveling from their office to destinations necessary in the representation of their clients will be paid for travel time and be reimbursed for mileage that is 10 or more miles. Payment for travel time and mileage reimbursement applies whether the travel is in or out of the attorney's home county. This policy will apply to attorneys who have offices over the state line who are appointed to represent indigent parties. What are the limitations or prohibitions in Rule 13? Well, there's primarily two. Just as attorneys are not to be compensated for time associated with traveling to a court in another county for the sole purpose of hand delivering or filing a document under Tennessee Supreme Court Rule 13, Section 2F, claims for mileage expense will also be prohibited. Generally, pursuant to Section 4B, expenses for out-of-state travel require a prior approval order that is approved by the court and by the AOC. So, that is also a limitation to mileage. If it's out of state, you need to have prior approval. We do allow one exception by policy, a narrow exception. And that is if the mileage will be less than 50 miles over the state line, we will pay that mileage without prior approval. And the reason is because we have so many cities that are right near the state line. Sometimes we understand that you're going to have to travel slightly across line and practically be in the same city where you need to travel to interview a witness. As required by Tennessee Supreme Court Rule 13, Section 4A, 3B, claims for mileage expenses entered into ACAP must describe the purpose of the travel and cities of origin and destination. So, for example, describe your travel by saying something like this: travel from office in Madison to courthouse in Nashville. That's plenty. That's all we need to know. One additional limitation set out in our policy is that where there are several claims for cases on the same day for which a mileage expense applies, that expense must be paid in one of the pertinent claims and not divided among the various claims. In other words, you had 6 cases at the same courthouse. You traveled only one time. Instead of splitting up the mileage on all 6 cases, just enter your mileage and travel time in one claim for those 6. That will take care of it. The policy before the revision was that travel time and mileage was compensable if the travel was out of county, but travel time was the only compensation that you would receive if it was in county. The revised policy basically eliminates the distinction between in county and out of county, but it does set a floor of 10 miles. We don't see a lot of claims for miles less than 10 miles. We thought that the advantage of being able to claim the travel time and mileage for in-county as well as out-of-county would certainly make up the difference. So travel time and mileage expense over 10 miles is compensable regardless if it is in-county or out-of-county at the current compensable rate for mileage. The revised policy simplifies the review process and accordingly allows audit staff to review claims more quickly, and it broadens payment of mileage now to include in-county travel. For these kinds of issues on expenses, take a look at the memo that is posted on the website tncourts.gov. For more information, check out the Indigent Representation webpage at tncourts.gov.